Larkin versus Grendel's Den, Incorporated, 1982. Grendel's Den is a restaurant in Cambridge, Massachusetts. Grendel's Den wanted to serve alcohol at their restaurant. So they applied to the Cambridge License Commission for a permit to sell alcohol. But Massachusetts had a law. Section 16C of Chapter 138 of the Massachusetts General Law stated, in short, a school or a church within 500 feet of the applying venue may object to the permit to sell alcohol, and on that objection alone the applicant will be denied. Next to Grendel's Den, just 10 feet away, is Holy Cross Armenian Catholic Parish. Holy Cross Church objected to Grendel's Den's application for a permit to sell alcohol, expressing concern with, quote, having so many licenses so near. The Cambridge License Commission voted on and denied Grendel's Den's application. The only reason the commission gave was Holy Cross Church's objection, noting that the church is within 10 feet of the proposed venue, thus falling under Section 16C. Grendel's Den appealed the decision of the Cambridge License Commission to the Massachusetts Alcoholic Beverage Control Commission. The state commission upheld the denial. Grendel's Den filed a case in the United States District Court, the federal court, against the Cambridge License Commission and the Massachusetts Alcoholic Beverages Control Commission, Larkin named as defendant. Grendel's Den argued Section 16C, both on its face and as applied, is unconstitutional. Because 16C is a state law, Grendel's Den challenged Section 16C on the 14th Amendment's due process and equal protection clauses. Grendel's Den also argued Section 16C violated the Establishment Clause of the First Amendment concerning freedom of religion. Another case addressing a similar issue with Section 16C was already in Massachusetts Supreme Judicial Court, the state court. The court upheld the statute, stating that Section 16C did not violate Due Process Clause nor the Establishment of Religion Clause. The U.S. District Court, the federal court in which Grendel's Den's case had been filed, disagreed with the Massachusetts State Court and found Section 16C did violate the Due Process Clause and the Establishment of Religion Clause. Larkin appealed the case to the First Circuit Court of Appeals. The First Circuit Court of Appeals, however, affirmed the district court's decision, also finding that Section 16C violated the Due Process Clause and the Establishment of Religion Clause. Larkin appealed again, this time to the United States Supreme Court. With Professor Scribe arguing on behalf of Grendel's Den before the court, the U.S. Supreme Court found that Section 16C, by a vote of 8-1, violates the Establishment of Religion Clause of the First Amendment. Chief Justice Burger, writing for the majority. Schools and churches have a valid interest in being insulated from certain kinds of commercial establishments. Zoning laws have long been used to protect institutions, such as schools and churches, from activities and businesses contrary to their missions, such as liquor and adult entertainment stores. However, zoning is in the authority of the legislative body of a government. Section 16C gives away the legislative power to deny businesses licenses to sell alcohol simply for being a certain type of organization, a school or a church, and by being within a certain distance to the applicant. This is not a proper delegation of legislative authority. Religion and government must coexist and must be insulated from each other. Jefferson's idea of a wall was a useful figurative illustration to emphasize the concept of separateness. Here, that wall is substantially breached by vesting discretionary governmental powers in religious bodies. The Church's power under the statute is standardless, calling for no reasons, findings, or reasoned conclusions. This statute enmeshes churches in the exercise of substantial governmental powers, contrary to our consistent interpretation of the Establishment Clause. Quoting Lemon v. Kurtzman, 1971, government is to be entirely excluded from the area of religious instruction, and churches excluded from the affairs of government. Section 16C violates just that. Justice Rehnquist, the lone dissenter, reasoned that Section 16C does not sponsor or subsidize any religious group or activity. It does not encourage, much less compel, anyone to participate in religious activities or to support religious institutions. In his opinion, to say that Section 16C violates the Establishment Clause by promoting religion is an error. And that is Larkin v. Grendel's Den, Incorporated, 1982.